All right, everybody. I want to thank you very much for taking the time to be with me here this evening. My name is Anthony Reeves, and we're going to talk a little bit about the importance of medical records and, more importantly, how far back you should go when it comes to medical records. When you're applying for Social Security disability benefits, one of the things you must do is you must provide Social Security with the date that you indicated your medical condition prevented you from being able to perform work as you normally performed it in the national economy, and more importantly, any of your past work or any other work. Now, a lot of times I get people wanting to ask for boatloads of their old medical records. And let me kind of give you a spiel of what I tell them. I said, first of all, there's a few things you got to keep in mind. Let's look at the type of the application that they have. First, if you have a Supplemental Security Income application or SSI, for purposes of disability, the relevant date is the date of the application when you apply. Why? Because that's the date you're going to get benefits anyway. So it doesn't matter if you applied today, but you said you were disabled 4 years ago. Doesn't matter if you have medical records going back 4 years. The key is that you have medical records around the time when you apply, because that's the date you look at. That's the first thing. Second of all, let's look at whether you have any other applications. If this is the first time you've applied in January of 2011, then that's the period of time you're going to really be focused on. However, if you've had another application, let's say you filed one back in 2009, well, now that application becomes relevant, because if we can open up that application, medical records around that time period may be helpful as well. I know this gets a little tricky, but I want you to follow me when I break this down for you a little bit. Sometimes getting older records for purposes of laying the foundation for background is helpful as it relates to, one, giving a good picture of the condition as it relates to today, and two, if you don't have a lot of medical records today but you had a lot back then, it can definitely be used to show the existence of your medical condition, or at least give a better picture of the severity of your medical condition. Now keep this in mind. Keep this in mind. When you're going back for old medical records, this is not the opportunity to take the kitchen sink approach. Please don't get the high pro glow and think that medical records back in 1992 or back in 2003 are relevant as it relates to your case. If you've got an attorney or a non-attorney rep, this is a good time to sit down and talk with them, because their focus is to make sure their medical records address the time period when you indicate your condition rendered you disabled. Okay? Now, also keep in mind, the medical records are not, this is not a kitchen sink approach. You can't, throw everything in there. When you caught a cold one day, when you stubbed your toe, or you had a little dizzy spell, it has to relate to your underlying medical condition. And that's what you need to understand as it relates to how far back you should look in terms of your medical records. This is the one thing that I find a lot of times people lose sight. If you, the Social Security file is a 5-step process, and the very first step of the process is, are you working? So if you're saying, oh, I got medical records that covered my disability back in 2000 to 2005, but you were working full time to 2000 2005, guess what? Those records might not be relevant or might not be helpful, because under the regulations, they may say you're working full time. So I don't see what the problem is. Keep those things in the back of your mind. I know this is going to be one other point you need to keep in mind. If you have a representative, don't be shy about asking them. If you think you have some records back that were older that might be helpful, ask your rep whether or not they think getting those records would be helpful. Don't tell them to go get them, because the fact of the matter is that depending on your relationship, whatever records they pay for, you're probably going to have to reimburse them depending on your relationship with your representative. But more importantly, your representative is going to want to focus more on the relevant evidence they have to help you win your case. They don't want to be running behind chasing records. And keep in mind this: if they go to hearing and they don't have everything because they're chasing all these extra records that you think are relevant that may not be relevant, your decision may be held up because the judge may not want to make a decision until they get those records. And the last thing you want to do is have some records out there floating that are not relevant, that's delaying you getting your decision. Now keep in mind this, one more point. I am not saying not to go back and get old records. That's not what I'm saying. You must evaluate those records in the context of your application and what type of application you have, the period of time you're asking for, and whether or not those records are relevant as they relate to your medical condition. I hope that helps out. As always, if you have any other questions, you can hit me up at legalbeat.anthonyreeves.com. Check out my blog. Of course, you can always send me a message here. I get a lot of messages from you guys, so keep them coming. You can always post a comment and always visit me at www.reevesfirm.com. It's been a pleasure, and have a wonderful day.